Good afternoon, everyone. Good afternoon, sir. I'm Rafael Eric P. Gibernas, and this is my report on Chapter 8, the Other Criminal Justice System. So, the first criminal justice system is Lesson 1, the Barangay Justice System. Got the Katarungan Pambarangay or Barangay Justice System is a community-based dispute settlement mechanism that is administered by the basic political unit of the country, the barangay. It covers disputes between the member of the community and involves the punong barangay or barangay chairman and other members of the communities which are the lupon members. As intermediaries, mediators, conciliators, and arbitrators, it was established by the mandate of Republic Act number 7160 or the Local Government Code of 1991. But before this law, the Barangay Justice System was also covered in Presidential Decree 1508 in 1978 and Batas Pambansang Building 337 or the Local Government Code of 1983. Cases covered under the Katarungang Pambarangay are also dispute, civil and criminal in nature, between parties actually residing in the same city or municipality that are subject to amicable settlement. No compliant, no petition, no action or no proceeding involving in any matter within the authority of the lupon should be filed or institute directly in court or any other government office for education, unless there has been a confrontation between the parties before the lupon chairman or the pangkat, and that no conciliation or settlement has been reached as certified by the lupon secretary or pangkat secretary as attested by the lupon or pangkat chairman, or unless the settlement has been repudiate by the parties thereto. Republic Act 7160 in section 412. Under the Barangay Justice System is a lupon tagapamayapa. So, the lupon tagapamayapa is the peacemaking council in the barangay. It is created in each barangay and it's composed of the punong barangay as a chairman and not less than 10 but not more than 20 members appointed by the punong barangay. The secretary of the lupon is also of the concurrent secretary of the barangay. The qualification to be appointed as a lupon are any person residing or working in the barangay of legal age with the following qualities. So these are the qualities that they need: integrity, impartiality, independence, fairness, reputation for probity, patience, resourcefulness, open-mindedness, and flexibility. So that are the following qualities to be a lupon tagapamayapa. So the function of the lupon tagapamayapa is exercise administrative supervision over the conciliation panels provided herein, meet regularly once a month to provide a forum for exchange of ideas among its members and the public on matters relevant on the amicable settlement of disputes. And to enable various conciliation panel members to share with one another their observation and experiences in effecting speedy resolution of disputes. And lastly is exercise such other power and perform such other duties and functions as may be prescribed by law or ordinance. So the next one is also under the barangay justice system. So it also gives contribution to the barangay justice system. So this is amicable settlement. So what is the amicable settlement? The lupon of each barangay shall have authority to bring together the parties actually residing in the same city or municipality for amicable settlement of all disputes. But there is a exemption. So these are the exemption where one party is the government or may where one party is the government or may subdivision or instrumentality thereof, where one party is a public officer or employee and the disputes relates to the performance of his official functions. Offenses punishable by imprisonment exceeding 1 year or fine exceeding 5,000 pesos. Offenses where there is no private offended party. So that are the examples of exemption. So the next one is the court in which non-criminal cases not falling within the authority of the lupon under this code are filed may at any time before trial. Refer to the case the lupon concern for amicable settlement. So this act is under Republic Act 7160 section 408. So where is the venue? So the venue of the settlement should be based on this following. So first one is disputes between person actually residing in the barangay shall be brought from amicable settlement before the lupon of said barangay. So those involving actually resident of different barangay within the same city or municipality should be brought in the barangay, where the respondent or any of the respondents actually reside at the election of the complainant. All disputes involving real property or interest therein shall be brought in the barangay, where the real property of the larger portion thereof is situated. So that are the venue of the settlement, where who is the larger portion. What we say if in our barangay, mas malaki yung Matina crossing, kumbaga mas malaki yung Matina Pangi kung sa Matina crossing, but they're same in the same municipality. That is objection to venue should be raised in the mediation proceeding before the punong barangay. Otherwise, the same shall deem waive any legal question which may confront the punong barangay in resolving objection to venue herein. Referred to may be submitted to the Secretary of Justice or his duly designated representative whose ruling thereon should be binding. So this act is under Republic Act 7160 section 409. There are two process of amicable settlement. So these are meditation and conciliation. So the first one is meditation. This process of amicable settlement where the complainant and the person complained of which the presence of lupon chairman shall meditate for the conflicting interest between the complainant and the person complained of. If the lupon chairman fails in his meditation effort within 15 days for the first meeting of the parties before him, he shall set a date for the conciliation of the pangkat. So that is the first process of the lupon chairman. So the second one is conciliation. So the process of amicable settlement where the pangkat tagapagkasundo hears and assists the disputes filed before the lupon, in which the lupon chairman failed to mediate. So after meditation, if the lupon chairman can't handle the situation, it will go to the conciliation. So the next one is also has a contribution to the barangay justice system. So this is pangkat tagapagkasundo. So what is pangkat tagapagkasundo? So it is the conciliation panel that hears each disputes brought before the lupon. The pangkat is composed of 3 members chosen by disputing parties from the list of members of lupon. If the parties fall to choose and agree on the members of the pangkat, the punong barangay shall determine it draw lots. The pangkat chairman and pangkat secretary should be elected among the 3 members of pangkat tagapagkasundo. The secretary shall prepare the records of the pangkat members of the secretary shall prepare the records of the pangkat proceeding and submit a copy duly attested to by the lupon chairman to the lupon secretary and to the proper city of or municipality court. He shall issue and cause to be served notice to the parties concerned. The pangkat shall meet both the parties later than 3 days from its constitution on the day and hour set by the lupon chairman to hear both parties and their witnesses, simplify issue and explore all the possibilities for amicable settlement. So within 15 days, which can be extended for another 15 days in a meritorious case, and issue subpoena of witnesses whenever necessary. The next one is suspension of prospective period of offense. While the dispute is under mediation, conciliation or arbitration, the prospective period for offense and case of action under existing laws should be interrupted upon filing of the complaint with the punong barangay. The prospective period shall resume upon receipt by the complainant of the complaint or the certificate of repudiation or of the certification to file action issued by the lupon or pangkat secretary, provided however that such interruption shall not exceed 60 days from the filing of the complaint with the punong barangay. So this article is under Republic Act 7160 section 410. Next is certificate to file action. So certificate to file action, it is a document by the lupon secretary or the pangkat secretary and attested by the punong barangay or pangkat chairman. It is issued when there was no settlement agreed upon between disputing parties. When there is such a settlement but later repudiated by the complainant because his consent to agree to the agreement was obtained through feud, violence, or intimidation, and or when the respondent failed to appear or refuse to attend a hearing without a valid reason. The issuance of a certificate to file action is ministerial duty. So the last one, the arbitration. So the arbitration is a process of amicable settlement wherein an arbitrator is optioned according to the agreement of the parties. So this process comes in any stage of the proceeding with the written agreement of both parties to abide by the by the by the arbitration award or decision of the lupon or pangkat. The parties are given 5 days to withdraw from the arbitration agreement. So the arbitrator could be the lupon chairman or the pangkat. They are given power to decide and render decision on the dispute or issue with the previous agreement of the parties. The parties then present evidence as to the facts and the merits of the cases to the arbitrator. The arbitrator decided based on the evidence presented on what the arbitrator believes to be just and fair. So the arbitrator must be natural and impartial in deciding which is also suitable to the disputing parties. So the arbitration award should be made after the lapse of the period and within 10 days thereafter. 10 days after. So the nature of the katarungang pambarangay proceeding is summary and informal. However, the lupon chairman or the pangkat chairman, depending on the case, may on its own motion or upon request exclude the public from the proceedings in the interest of privacy, decency, or public morals.